it being dismissed. Well, of course, the application was brought by the ANC around this trademark infringement claim that they'd been making. That matter dismissed with costs. Let's bring in just a legal perspective on this now. Advocate Khumisi Kganare joins us now. Khumisi, good morning to you, and thank you for your time. You heard Dali and Mpofu there, not giving away too much, but of course this is a moment for them to celebrate in court, and you can hear from the the statements and sentiments expressed by the MK party. This has certainly gone the way that they wanted it to go. Not much was shared in terms of the reasoning behind the judgment. Is this normal in this sort of case, that you would just get a decision and you would get, if there's a cost order, then that cost order would be given? So we're not quite sure on whether there were any other details that needed to be provided in terms of this judgment. Just share with us your perspective legally.
Yeah, sure. I mean, it happens sometimes that you get an order that doesn't necessarily, come with reasons for it. But court would be given, some time to then give out reasons that relate to the judgment itself. Because without the reasons for judgment, then you're not able to immediately appeal, because you need to get those reasons so that you apply yourself and are able to, appeal if you so wish. So it's not, perhaps there are reasons that go with the judgment that was handed down today or not. We're not sure, but ordinarily that's how it would pan out.
And it was so quick. We almost missed it. Usually, there'd be this whole kind of, protocol that gets followed, a court protocol and so on. And then they normally would, kind of take a little bit of time, even if they're just giving sort of the heads of their judgment. But today, that was quick, in and out quite quickly.
Yeah, sure. No, definitely. And I mean, there's nothing wrong with that. And my assumption is there's, possibly reasons for judgment that also go as part of that. If not, then they should follow in a few days' time, so as to allow everyone to know why the decision that was taken and how court got to this particular decision.
Yeah, I mean, it really is an interesting moment. I know that you can't speak politically, so we want to just kind of keep it in the legal terrain. There was a lot of discussion about the parameters of the claim that was being made, or the argument that was made by the ANC with respect to the ownership of this particular brand. They hadn't registered the trademark or the patent for it, essentially. And so this was such an important and I think interesting case to delve into and to understand. But as it stands, MK can use that logo now as it had envisaged. Even though there were some modifications to the original logo, it's theirs. To use, I mean.
Yes.
To use.
Yes, no, true. And I mean, trademark law is becoming even more interesting now that, we experience these sort of battles, especially in the political space. And when you have, an issue with infringement as, a proprietor of a particular brand, logo, slogan, whatever it is, you can approach that by way of, the Trademark Act. That's one way. The other way would be to approach it by way of common law, where, you would be arguing unlawful competition, you would be arguing passing off. And immediately when you go the latter route, it becomes a bit tricky. Then what it says to everyone who is watching is, if you cannot pursue your claim in terms of the Trademarks Act, then it means you do not have a registered trademark. And as a result, you cannot produce evidence that says, on such and such a date, I filed for application. After a period of about 2 or 3 years, then I was issued a registration certificate. If you don't have that, then you can pursue a passing off argument, which is what happened in this instance. And when you talk passing off, it becomes a bit of a step for you to then argue, because you are going to have to go back into history to get evidence that talks to goodwill, that can link whatever you allege to be owning as a trademark to be yours. And that's not an easy thing to do. And you will see even in this case that, evidence was all over the place, and it couldn't necessarily be linked directly to the ANC in terms of ownership of this logo. the ownership was sitting, with a different entity and not necessarily the ANC, and there were agreements in between to sort of link it with the ANC, where there's an arrangement between that independent, separate organization to say, look, we're giving you rights to use this. And in the midst of all of this, then again, you see the ANC, running to the CIPC to go register in September. And when you file for registration, it's not a quick thing. Yes, you can file in September like we have seen it now, but the process that takes you to a registration certificate, it can take about 2 to 3 years, where the mark is then advertised, people are invited to object, and it's a very long process. So it was not going to happen that just between September and now a registration certificate will be issued. And in a case like this, where ownership of Mkhonto Sizwe and availability of its registration is in question, you're not even guaranteed a certificate at the end of the process.
But where do we stand now with this matter, Khumisi? On the one hand, with the ANC, and we don't know yet the basis on which or reasons for which this was decided upon, and it's gone MK's way today, and I'm not sure, as you say, whether that might still be provided. But are there legs for the ANC to pursue this further?
Look, there's always an avenue to, take the matter forward, as long as we haven't gotten to, the last court in the land. There's still the Supreme Court of Appeal where they can go. There's still the Constitutional Court where they can go. But it all boils down to the evidence and facts around the case. Even if you take what are your prospects? Looking at what, because you got an opportunity now at the High Court. I am sure you went all out in terms of facts, in terms of evidence, and if that court could not, find in your favor, you have to assess again going forward. Same facts, same evidence. You can't then later, want to produce something that was not produced in the High Court. So again, prospects of success, become very, very slim, even if you take it further. But they do have a right to do so.